all across America and around the world. This is Veterans Radio. This is Veterans Radio.
Welcome to Veterans Radio. I am Jim Fausone. I'm the officer of the deck today. We've got some great programs for you. I think you'll find very interesting. We always want to remind you can find more about Veterans Radio at its Facebook site or at the web. Veteransradio.org is our new URL, veteransradio.org, where we're on the web 24/7. You can find a lot of our podcasts there as well. We post new ones every Tuesday, so you can get a new story, a new interview, something you didn't know before by going to veteransradio.org. And before we get started, we want to thank our sponsors. First up, we want to thank National Veteran Business Development Council, nvbdc.org. It was established to certify both service-disabled and veteran-owned businesses. You'll find out how they can help your business by going to nvbdc.org. We want to thank Legal Help for Veterans. Legal Help for Veterans fights for veterans' disability rights all across the nation. You can reach them at 800-693-4800 or on the web at legalhelpforveterans.com. We want to welcome to Veterans Radio today Professor Jason Mazzone. Jason, welcome to Veterans Radio.
Thank you so much, Jim.
Now, let me set this up. The professor is a professor of law. Don't get scared off. He's a good guy. He is the Albert E. Jenner Jr. Professor of Law at the University of Illinois at Urbana-Champaign and director of the Illinois program in Constitutional Theory, History, and Law. And he was brought to our attention by an interesting article, a recent article in the Army Times about who owns the National Guard, and a court decision down in Texas that will have some implications on that. But I should also say that Professor Mazzone's, he got his undergraduate or master's, I guess it was, at Stanford University. He has his JD, his law degree from Harvard Law. He also picked up a master's in law at Yale Law School. So he's deep and wide in these legal issues, and we're going to drag him over to the military and veterans side. So, Jason, you ready to give this a try?
Yes, I am. Let's do it.
So, as I said, it's an interesting article that caught my attention in the Army Times, and it was over a lawsuit filed, as I understand it, by the Texas governor, Greg Abbott, over his legal fight against the Pentagon's requirement for COVID-19 vaccines. And
right.
he didn't want his Texas National Guard folks to have to comply with the federal requirement, and that's sort of the jump start of this dispute, isn't it?
That's right. So Governor Abbott sued the Biden administration to block it from enforcing, by punishing members of the Texas Guard, this COVID vaccination requirement, as you said, Jim. And Abbott's position was an interesting position. He said, so long as the Guard has not been mobilized by the federal government, so long as it's not in federal service, the federal government, particularly the president as commander-in-chief, lacks authority under the Constitution to punish guardsmen for failure to follow a federal order, in this case the vaccination requirement. That under the Constitution, that power is reserved to the state, and particularly in this case to the governor, to impose a punishment in the form of a fine or a discharge or a court-martial. If you mobilize the Guard, then yes, you, President, can impose a punishment for failure to be vaccinated. But until that happens, and the Guard is just under normal state oversight, there's no authority, Abbott said, under the Constitution for the Commander-in-Chief, the President, to impose any sort of punishment against guardsmen for failure to comply with a federal directive.
So you see how this issue, I don't know if it's political or social issue between the governor and the president over something that was controversial, the COVID vaccines, gets played here. And the professor mentioned numerous times it's a constitutional issue. Who's got the power? Now, we all know, anybody who's served and been around the military knows that when you're on active duty, it's the president. He's the commander-in-chief. But the National Guard in all 50 states really report up to the governor of that state, who's in charge and the commander-in-chief. And it's more important today than ever as we come off our 20-year war in Afghanistan. There's about 1.4 million active duty members in the U.S. military, but there are 450,000 active guardsmen in the states. So that adds to the strength of the military by about 32%, and they were all used pretty much in Afghanistan. So you see that this isn't a small issue. It's kind of, while it's a little wonky, Professor, it's like a real issue of who's in charge. And what did the courts say about this?
Well, so this was filed in federal district court by the governor. The governor lost in federal district court. He then appealed to the U.S. Court of Appeals for the Fifth Circuit, which is the intermediate federal appellate court. It's one step below the U.S. Supreme Court. And there, the U.S. Court of Appeals for the Fifth Circuit agreed, at least at this stage of the case. It's still in a preliminary stage of the case where Abbott is seeking an initial order blocking any punishment against guardsmen. But the U.S. Court of Appeals for the Fifth Circuit disagreed with the conclusion of the lower court, the district court, and suggested that its view was that Abbott had a quite good legal argument under the Constitution, sent it back down to the district court for it to reassess its prior order, with a pretty strong hint that Abbott should prevail, at least this stage of the case, where, again, he's seeking a preliminary order to keep things as they are, to maintain the status quo, to prevent the federal government from punishing any members of the Guard while the case proceeds in the federal courts. And so, where things stand at this point, it's before the trial court again, but following this pretty strong suggestion from the Court of Appeals, the intermediate appellate court in the federal system, that Abbott's claim has some real merit, that the president, the Department of Defense, lacks authority until guardsmen are actually mobilized to discharge them, or to court-martial them, or to fine them, or to do anything else by way of punishment. And the circuit court's reasoning was based upon these old provisions of the Constitution that don't say anything about the National Guard, because there was no such thing when the Constitution was drafted, but they refer to the militia and who controls and has power over the militia under the original Constitution. The court took the view that the Guard is equivalent to the old militia, and so those militia provisions of the Constitution that divide power between the national government and the states, that they apply to the Guard today in the same way that they apply to the militia. And the circuit court said, if we look at these provisions, yes, the federal government has certain powers, but it said the power to provide for governing the militia only belongs to the national government when guardsmen are in federal service. And the power to govern includes the power to punish. And so a kind of straight-up, plain reading of the text of the Constitution, the circuit court said, means that until there is mobilization of guardsmen, in the same way as would have been true with respect to the militia, the power to impose punishment is one that belongs to the state. If you want to punish, you have to wait, federal government, until you've actually called the Guard, or in the historical case, the militia, into federal service. That's what the Constitution says.
Well, and that's the issue that kind of dragged Professor Mazzone into this from the University.
Oh, this is great stuff. I mean, this is, so you might think, oh, this is a kind of specialized issue today, but historically, control over the militia, this is one of the biggest issues of the Philadelphia Convention, right? This sort of concern about national security and how you're going to make sure that you have sufficient security personnel, kind of concern about a large standing army, and so instead of that, will allow the national government to deploy the militia in certain circumstances. But we're concerned about that because the militia is really an entity under state governmental and local governmental control. So you have to be very careful about the circumstances under which we're going to allow the national government to exercise authority over those old militia forces. And this is the kind of compromise that is worked out at the Constitutional Convention, 1787, gets adopted as part of the Constitution within the next 2 years. And here we are today, talking about essentially the same question, but in the context of COVID vaccines, which of course nobody had thought about in the 1780s, but really raising the same basic question: who gets to decide? Who's in charge? And here the court says, well, the Constitution tells you.
Well, and it is relevant today, and that's kind of why the article caught my attention, and I wanted to talk to Professor Mazzone, who has researched and written a lot on this issue of the militia clause. That was quoted by the court, which is always a nice thing, makes you feel good that somebody thought your work was...
I live for that. I mean, that's what law professors live for, yes.
But it's relevant today not only because of this COVID dispute, but those of us who've been around for a while can think back when we were required to take the anthrax vaccine.
Right.
And there was a lot of dispute about, hey, I'm not going over there. Why am I taking this? And I can project it forward by saying we have a lot of states that allow marijuana use, and both medically and recreationally, but the federal government doesn't. So who gets to decide whether somebody gets disciplined because they test positive for marijuana? And
right.
So this issue is going to go on for a while.
That's right. And most of the time, as you said at the outset, the federal government and the states, the president and the governor are basically on the same page. But the issues emerge when they're not. When the governor of a state, as here with respect to Governor Abbott, thinks that there's a kind of punishment being imposed that is unwarranted. So that's really where these sorts of issues can emerge. And when they do emerge, they can be really important. I mean, this question of whether the federal government can actually impose this directive against militiamen or National Guardsmen who are not yet in federal service for failure to do what? Failure to obtain a COVID vaccine, an issue as to which there was, of course, a great deal of controversy.
And the government argued in this case, as I understand it, at the Fifth Circuit, hey, we, the federal government, give these state National Guard troops plenty of money and plenty of training when they're not federalized, and therefore, because we give the money, we get to control the strings that go with it. I'm sure that's an oversimplification, but wasn't that the basic argument?
That's absolutely right. The government had several arguments, but one of the arguments, as you point out, Jim, is look, we're paying for this, right? Yes, we understand the distinction between guardsmen who have not been mobilized and those who have, and we certainly understand that as a distinction. But even when guardsmen are not yet in federal service, they're being supported significantly through federal dollars. And if we're paying, we should be able to call the tune. And as a condition of you, state, receiving this money for your National Guard, we are attaching this requirement that they be vaccinated. And the circuit court said, there are lots of circumstances in which the federal government can give out money to states and attach various sorts of conditions to those grants. We see this a lot in the context of education and so on, where the federal government makes financial grants to states and says, if you want the money, here's what you got to do in return. But the Circuit Court said that condition, though, that is attached cannot be a violation of the Constitution. And here, the government is essentially saying to the states, you must do something that itself is not permitted under the Constitution. And so that's a limit on the ability of the federal government to impose conditions upon federal grants. You cannot require militiamen to be vaccinated unless they're, guardsmen to be vaccinated unless they're in federal service. And you cannot impose that as a condition on a grant either, because you can't force the states to agree to things that violate the Constitution as a condition of receiving money. And so the government lost on that point as well.
So there's a veteran radio listeners, Professor Jason Mazzone of the University of Illinois, just gave you the synopsis of the first year of constitutional law and a very expensive education. You can't put conditions on that violate the Constitution. Seems simple when you say it like that.
It's a basic principle. You don't get to bribe people to get around constitutional limits.
Now, I'm going to back up a little bit because this is such a unique little area, but how the heck did you get so interested in the Militia Clause and research and writing it that you find your way into the Fifth Circuit opinions?
I've always been interested in the security elements of the Constitution. When we teach constitutional law, as we do to first-year students, we spend a lot of time talking about government powers and individual rights and so on. And it struck me when I first started teaching that a large theme of the Constitution is national security. If you sort of think about a dominant theme in the document, that's what it is, that there are provisions throughout the Constitution that anticipate that there will be national security problems on the horizon, and provide for some kind of effective response to that. Today, of course, we don't often think about the country being at risk of being invaded and or subject to internal insurrections and other kinds of security challenges. But for Americans of the 1780s, this was the thing that they thought a lot about: invasion or individuals in the country who were waiting to topple the government. And they built a constitution that anticipated that there would be national security challenges and anticipated the need to have an effective response to them. And central to the design that was created was, as I said earlier, this division of authority over the militia in a context in which you had minimal professional soldiers, and there was a general concern about a large standing army. The militia was supposed to be your principal fighting force. And so there are lots of provisions throughout the Constitution that deal with this issue of the role of the militia with respect to national security, and the more important question of who gets to direct the activities of the militia. So this is a big theme of the original Constitution, and in some ways it captures many of the concerns that were in play at the time the Constitution is adopted, concerns about division of power between the national government and the states, questions about the role of ordinary Americans, because that's essentially what the militia was in security operations and in the operations of government more generally. And so these are sort of old provisions that were very important in 1780s, and after which I think you can learn a great deal about the Constitution in general if you kind of dust them off and think about them. And then occasionally you get an exciting case like the one out of the Fifth Circuit that actually talks about the militia, which, is kind of unheard of. There are very few cases in which you get an extensive historical discussion. So these things that you sometimes think are no longer relevant can actually, as here, turn out to be incredibly important still.
So somebody out there is thinking, and certainly the government attorneys did, that said, hey, the Constitution talks about a militia. It has nothing to do with the National Guard. It doesn't look like the National Guard. It's a totally different concept. You can't take that archaic idea from the 1780s and bring it forward. What say you, Professor?
I think there's something really to be said about that. There are real differences between the old militia and the National Guard. I mean, the old militia, in sort of the true historical sense, was every adult male citizen, right? That was the idea. The National Guard is, of course, entirely voluntary, and it's a subset of the population. The militia was organized as a local institution under the authority of the state. The National Guard, I think, is much more integrated into the federal military structure than the militia ever was, or that anybody thinking about the militia ever thought that it would be. The national government pays for the National Guard in a way that wasn't true of the militia. So I think there's a lot to that. I think that equating the old militia with the National Guard is not a slam dunk. But here's what's happening in the background. The National Guard itself says we are the modern version of the militia. If you look at the Army National Guard website, it says we were founded in 1636, right, in the Massachusetts Bay Colony, where the first militia regiments were created to defend the colony against attacks by Indians, and we've been in place ever since. So that's the view of the National Guard, and it turns out to have been the view of the Biden administration in this case when the administration is sued by Governor Abbott. It says to the courts in this case, apply those provisions in the Constitution that talk about the militia, because that's what the National Guard is. And so, once you kind of cross that bridge, well, then you're into the old restrictions that were in place with respect to federal authority over the militia. So this was not an issue that was ever debated or disputed between the parties in this particular case, which is the reason that there's so much attention in the decision of the Fifth Circuit to the meaning of those old militia clauses of the Constitution, because everybody involved in the case says the National Guard is what the Constitution is referring to when it says militia.
Be careful what you ask for; you may just get it. So,
yeah, I wonder whether they regret, conceding that or not disputing it. But it's hard to do that if you're the government and the National Guard on its own website says we are the militia.
Yeah. So here's the $64,000 question that I'd only ask because you're the Albert E. Jenner Jr. Professor of Law at the University of Illinois at Urbana-Champaign, which is, how does this play out?
Well, it's back in the federal district court, which is the trial court. We'll see what it does with a sort of strong hint from the U.S. Court of Appeals for the Fifth Circuit to issue a ruling in favor of Governor Abbott, blocking any sort of punishment imposed by the national government on guardsmen for failure to obtain the COVID vaccination. So then the question is, what happens after that?
Does it make
will the Biden administration go to the U.S. Supreme Court?
Right, that's the question. Does it end up either way? Does somebody say, well, the Supreme Court's got to answer this?
Right. And ordinarily, the Supreme Court is unusual among our courts in that it gets to decide which cases it wants to hear. Ordinarily, though, if you have a circuit court, the intermediate appellate court, invalidating something that the federal government is trying to do, that's generally a case that the U.S. Supreme Court is interested in taking. And we have on the Supreme Court a lot of people who are very interested in constitutional history, so they might just take it for the fun of it.
There you go. Only a law professor would see the fun of it. Jason Mazzone, professor of law, we really appreciate you taking the time to help us understand the controversy of who's really in charge of the National Guard and who gets to set those kind of rules. If this continues on, I'm sure we'll be talking again. But again, thanks for your time today, Jason.
My pleasure, Jim.
And I want to thank everybody for listening to Veterans Radio today. I am Jim Fausone. It's been a pleasure to be your host. I'm a veterans disability lawyer at Legal Help for Veterans, and you can reach us at 800-693-4800 or legalhelpforveterans.com on the web. You can follow Veterans Radio on Facebook and listen to its podcasts and internet radio shows
by visiting us at veteransradio.org. That's veteransradio.org.
And until next time, you are dismissed.
If you have a VA claim denied by the Board of Veterans' Appeals, contact Legal Help for Veterans at 1-800-693-4800. They're experts in handling cases before the U.S. Court of Appeals for Veterans Claims. Their number again, 1-800-693-4800.
We again want to thank our national sponsors, the National Veterans Business Development Council, NVBDC.org, VA Ann Arbor Health Care System, the Vietnam Veterans of America Charles S. Kettles Chapter, Ann Arbor, Michigan, VFW Graf O'Hara Post 423 in Ann Arbor, and the American Legion Press Corn Post 46, also in Ann Arbor. We appreciate all your support. You can go to veteransradio.net, click on the sponsor level, and continue to support keeping Veterans Radio on the air. And until next time, you are dismissed.
With the Lucky Land Slots, you can get lucky just about anywhere.
This is your captain speaking. We've got clear runway and the weather's fine, but we're just going to circle up here a while and get lucky. No, nothing like that. It's just these cash prizes add up quick. So I suggest you sit back, keep your tray table upright, and start getting lucky.
Play for free at LuckyLandSlots.com. Are you feeling lucky? No purchase necessary. Void where prohibited by law. 18+ terms and conditions apply. See website for details.